and welcome. Thank you again for joining us today for Access on the Line, Appeals, Detention, and the Future of Immigration Due Process. I want to thank you all for joining us today. My name is Adonia Simpson. I am Deputy Director overseeing policy and pro bono at the American Bar Association Commission on Immigration. And we are incredibly grateful for the opportunity to spend this little bit of time with you today to discuss these issues, as well as your continued commitment to and partnership to strengthen access to justice in the immigration system. By way of housekeeping, I do want to remind you all, please use the Q&A. If you have any questions during our discussion today, we'll be happy to try to address them as we go through. And please, we'll be sharing some information in the chat, but please direct all your questions through the Q&A that should be located at the bottom of your screen. Today's briefing comes at a moment of significant change. Over the past year, we've seen increased enforcement, a series of procedural shifts that have reshaped how immigrants move through the immigration court system, including a potential new appellate procedures before the Board of Immigration Appeals, sharp increases in fees, and evolving practices of pre-termission and changing standards for bond determinations. These changes are compressing timelines, raising barriers, and narrowing opportunities for individuals to obtain meaningful review of their cases. Even since we began planning this session several weeks ago, we've already seen shifting policies and pauses due to litigation that we're going to be discussing later today. At the same time, the people most affected and impacted by these changes are often those with the fewest resources, individuals who are detained, navigating the system without counsel, or seeking protection after fleeing violence or persecution. The practical impact of these changes is really best understood through the experiences of the advocates and attorneys working on the front lines of the system every day, many of whom are joining us here today at this session. And that is why we're particularly grateful to be joined by leaders from three of the ABA's immigration programs, the South Texas Pro Bono Asylum Representation Project, ProBAR, the Immigration Justice Project, IJP, and the American Bar Association's Commission's National Detention Hotline. These programs operate in border communities and detention centers, providing legal services and critical orientation information to thousands of individuals every year. Today's conversation is intended to give you a clearer picture of what you may be reading in the headlines, what it actually means in practice, and what you can do to help preserve fairness, representation, and due process in this rapidly shifting environment. I'm going to quickly introduce our panelists today, and we're going to get into a discussion, ask some questions. So first we have Kiana Aguirre-Ryan. She's a staff attorney with the Commission's National Detention Hotline. Thank you, Kiana, for joining us today. We have Amy Korolev, Deputy Director at ProBAR, based in Harlingen in Houston, Texas, providing legal orientation and services to detained and non-detained adults and children. And finally, Amanda Bernardo, Deputy Director at IJP in San Diego, providing representation services to detained and non-detained individuals and families. So thank you all for joining us today. We have a short amount of time, so we're going to kick it off. Kiana, I'd like to start with you. If you could briefly tell us what the detention hotline does and how you've pivoted to kind of meet the current needs and demands of callers.
Thank you so much. Hello, everyone. My name is Kiana. I'm a staff attorney at the ABA's Commission on Immigration National, and I predominantly work on our detention information hotlines, and I'm very grateful to be here all with you today in community. Here at the ABA's Commission on Immigration, we have two detention hotlines. We provide legal information and orientation to people detained in ICE custody. First, we have the ABA Detention and Information Hotline. This is a hotline where volunteer immigration attorneys take calls from folks detained in ICE custody with an ABA staff attorney available throughout the entire call as a mentor. And then second, we have a partnership with UNHCR, the United Nations UNHCR Detention Information Hotline that is managed by the ABA staff members. Both hotlines are accessible and free of charge nationally in ICE custody. We don't provide legal advice, we don't provide legal representation, but we do provide orientation on a whole range of immigration topics, ranging from forms of immigration relief like asylum to more complex issues such as appeals procedures. We can connect people to attorneys, nonprofit organizations on the ground through referrals. We can track detention, conditions, complaints that callers share with our staff, and we can send packets and immigration guides to our callers as well. Lastly, in terms of how our work has changed, it's changed a lot over the past year and a half. But notably, our staff has had to be very adaptable. We've had to be very flexible to address the needs of our callers and those shifting needs with the changes in policies and guidance and rules. We have to make sure we're up to date on these changes and laws and policies. We have to make sure we're up to date with detention trends to share with our callers that are impacted. We've also been building out legal referral systems to make sure folks are connected to organizations on the ground that can assist. And as a team, we've really been working to update our legal guides, legal immigration guides that we send to our callers so that they're very informed of changes in policy that can impact their case. So with all that being said, it's been challenging given the sheer number of changes in immigration law. But as a team, our priority is and always has been to make sure our callers know their rights and are well informed to make these decisions in their cases.
And I'm sure when you're kind of, making these guides and updating this information, it can be really challenging because oftentimes these policy changes or decisions that are coming out are incredibly complex and trying to make them accessible to individuals. I'm guessing is not necessarily easy, and not to put you on the spot, but what has been some of your approaches in trying to make sure that the latest information is in a way that's accessible to those who are calling?
Right. Thank you for that follow-up. There's changes happening sometimes weekly, sometimes daily. So at times we're prepared with our up-to-date orientation, and then while we're on a hotline shift with an individual, there can be another change. So it's really important that there's not misinformation being spread, which unfortunately is the case often for a lot of individuals in detention through word of mouth and through so many changes. So as staff, we meet weekly to be able to make sure we're all on the same page and all giving the same information to our callers. On our detention and information hotline, we also have a document titled a talking points document that we share with our volunteer attorneys so that when they're on calls, they feel very comfortable regarding changes in policy, and that's always relayed to them before they take on a shift through the mentors that are on the calls.
And I've seen that talking points document, and it's quite robust and it has a lot of incredible information. I want to narrow down on a most recent change and update. There was some potential a new interim final rule regarding the Board of Immigration Appeals and the appellate process. And even with that, as I highlighted earlier, we've seen some litigation and some things on it in pause. Can you explain really briefly what this new rule is and how it's impacting folks who are in detention, folks that are calling the hotline, or just in detention generally?
Yes. So just to briefly touch on the rule that I see has been included in the chat as well. In February of 2026, last month, the Department of Homeland Security introduced a new rule on Board of Immigration Appeals, and the acronym for that is the BIA. So this is essentially the appellate court in immigration proceedings. Originally, this new rule would have applied to anyone who planned to appeal an immigration judge's decision from on or after March 9th of this year. However, we did get news that prior to the decision taking full effect, a district judge issued an order preventing the most harmful parts of the rule from going into effect. And there was three parts I wanted to highlight briefly that were vacated and blocked, meaning they no longer apply. That would have been really detrimental to the immigrant community, specifically in detention. The first part is the filing deadline of the notice of appeal. The notice of appeal is the first step in the immigration appeals process. So if you get a removal order and you want to appeal the judge's decision, this is the first step you must take. Normally, you have 30 days to file this notice, which in and of itself is also a short amount of time, especially if you're detained. This rule wanted to change that to just a mere 10 days. Thankfully, this part of the rule was blocked and set aside. Second, the BIA would have been able to summarily dismiss appeals, meaning they could deny a case without a full review of the merits and the arguments on the appeal. This part was also blocked. And lastly, the other part of the rule that was blocked was any issue not raised in the notice would have been waived, which would have meant folks would have had to been very detailed in the first step of the appeals process. Um, I also wanted to just briefly mention that aside from this new rule, there has also been increased fee changes that impact one's ability to appeal. The filing fee for an immigration appeal is now $1,030. There is a fee waiver, but it's important to note this fee has made appealing even more challenging than it was before. The one part of the rule that remains in effect, but litigation continues to be pending, and if you see in the chat, there is a comment that the ABA did submit regarding this rule, is in the past, once someone filed their notice of appeal, again, which is the first step in the process, the board would set a filing deadline to submit written arguments. So your arguments in detail regarding why you disagree or agree with the judge. But with this new rule, folks only have 20 days to submit written arguments, and there's no ability to file a reply argument or a reply brief. So this is in effect as of March 9th and currently is in effect. But like I said, there's still a comments period open, and our comment specifically from the ABA is listed in the chat. So that's the rule, and a brief explanation about that. And briefly, before I pass it on, regarding how the rule impacts our work. Callers to our hotline are representing themselves and they're detained. We receive calls from detention centers in remote areas with very minimal access to legal resources. Mailing from detention centers can be very lengthy, impacting one's ability to ensure things are timely filed. And callers often need legal information and orientation to be able to fill out the form, complete the required steps. They may need help translating their documents because all documents must be submitted in English. They may also need the actual physical form itself to file the appeal, given some of these detention centers don't have access to those forms or a law library where one could access these forms to continue with the appeal. And in immigration proceedings, you have a right to look for an attorney, but at no cost to the government. So many of our callers, unfortunately, have to represent themselves. Lastly, on that note, if one doesn't have the full record of proceedings, meaning the immigration judge's order and what happened at the hearing and why the judge ordered deportation, it's challenging to draft a detailed appeal. Meaning a lot of people not only need to represent themselves during these proceedings, often not in their native language, but also they have to take notes to be able to cite to in their appeal. And if the BIA appeal is dismissed or denied, then they have to navigate a very complex, higher level appeal process, all while also risking deportation to these countries that they fear being returned to. So it has very much made it more complex when it's already been complex prior to this new rule being in effect.
Thank you for that information. And Kiana, I want to direct it to you. There is a question in the Q&A, if you wouldn't mind maybe responding to it in the interest of time, if you could do it via the Q&A. So that's one big change we've seen just recently. I think something that's been kind of evolving for a while now is what's happening with folks who are detained and their access to bond and prolonged detention. Amy, there's been a lot of changes this last year. Can you tell us about the work that ProBAR is doing and what you're seeing on the ground today with respect to bond and people seeking release, and how it's impacting your teams and your staff, but also the clients you're serving?
Yes, thank you, Adonia, and thank you all for being here today. My name is Amy, and I work at ProBAR. We are an organization working down on the border in South Texas, if you're unfamiliar. And there we work with a lot of detained individuals, both children in youth detention facilities, as well as detained adults in two very large facilities at the Port Isabel Detention Center and the El Valle Detention Center. And, we've been really working with those detained populations for over 30 years. And we've really seen the ups and downs and changes that have affected those that are detained. But one thing that has been pretty constant is this idea of someone that if they are detained, they have this option to pursue bond or an ability to go before a judge and say, I'm not a flight risk. I'm not a danger to the community, and I'll show up to my court hearings. I don't need to be detained, and I'll present this sum of money, if necessary, to show that I will comply. And really, what we've seen last year going into this year is this systematic way of just eliminating any option to bond for any individual. We've always had mandatory detention. So there are certain categories of individuals, those with certain criminal convictions, or those that are labeled as arriving aliens, or those that have gone through ports of entries to enter. That's not new that they're not able to access bond. What is new is a series of ICE releasing documents and changes in protocols, and many cases that say those that have entered without inspection, who have historically always been able to apply for bond as a matter of course, are now seeing barriers to being able to apply for bond. So we had a series of decisions before us in the last 6 months that have both restricted access to bond for this category of individuals, then reopened it, then restricted, and then kind of reopened it. So what we're seeing now on the ground in terms of bond is technically those that fit into this category of individuals that entered without inspection and don't have other barriers can hypothetically fit into a class under the Maldonado-Bautista litigation and apply for bond. Nevertheless, we're seeing many immigration judges saying, no, we have this earlier decision that did not overturn it. We are not applying this precedent. I have no jurisdiction to make a ruling on this bond. You must stay detained. And so really, we're seeing that play out across the country. Now, some judges in jurisdictions are allowing bond, but many aren't, citing these reasons. In the Fifth Circuit in particular, which is where we're located in Texas, we saw two subsequent decisions that further, put a nail in the coffin, so to say, that said, no, you cannot access bond. And if you attempt to pursue a habeas corpus action in federal court citing the Maldonado-Bautista action, your habeas will also be denied. So what does that mean in practice? So let's say that an individual is detained in this category, and they may be in New York detained. So hypothetically, they could potentially access bond. They could potentially try habeas. But what may happen is that they're transferred to a facility in the Fifth Circuit to further restrict their access to get out of detention. So really, really challenging issues with bond, and it's made it hard to really be a practitioner working with individuals that are detained, because it is demoralizing to see that, that they're getting these notices that say, hey, you're part of this class in Maldonado Bautista, you should be eligible for bond. But really, the immigration judges are not granting bond. They're still continuing to say, I don't have jurisdiction. So it's made it really hard, and had some individuals really lose faith in their attorneys because they have this notice in their hand. They say, oh, I know other people are getting out, but they're not able to. It's really, really challenging. So, this idea of no access to bond is really one of the items that is really emphasizing this idea of prolonged detention. We are seeing individuals detained longer than ever before. We are seeing this both with the youth, so those that are unaccompanied minors that may be detained in the youth facilities, as well as those in adult facilities. And what do I mean by prolonged detention? So those that have been detained for 3 months, 6 months, 1 year, over a year and a half. In many of these cases, they have a final decision on their case. Maybe it is a removal order, so they were unsuccessful in um, in their application for relief, and yet they're still detained because the government is unable to send them back anywhere. Others, they're still awaiting their chance to litigate their case or they're pending appeal. And it has really led to just skyrocketed numbers of those in detention fitting into these categories. Um,
And I imagine on that, like with this prolonged detention, you mentioned how difficult it is on the staff and the attorneys working with
mhm.
individuals that are up against this. I imagine the psychological impact on folks that are detained for who knows how long is also pretty great. Are you seeing that shift on how people are maybe choosing to proceed on their cases?
Yes, it really has affected individuals. Many are receiving negative decisions or denials in their cases, even if they have really credible reasons to stay, those that could have opportunities on appeal, and they're not willing to wait for additional months in detention while they pursue an appeal. They're not willing to fight it or to risk it. They're saying, okay, I'd rather just get out of detention. I'm ready to go back. And that makes a lot of sense, in theory. Okay, I want to go. It's hard to hear as somebody that wants to advocate. Um, but what we're seeing for many of those individuals that even in that posture, they may be sent to a facility in South Texas awaiting their deportation flight. And those individuals are being admitted into our facilities in something called, the government is using this language, a courtesy hold. And that means that they are coming to a detention facility, but they're not being admitted in. They're not being processed as somebody being held in the facility. Currently at Port Isabel, we have 480 individuals that are being held on these courtesy holds. So what does it mean if they're not processed? They're physically there. We know they're there. We can see them, but they're not on the ICE detainee locator. They're not, for the most part, admitted into a housing unit. They have restricted access to clothing, a change of clothing, um, to food, to medical resources, to the library. We've heard reports that some are able to access a shower, but only once a week and only for 2 minutes, and no soap is provided. We heard that these conditions, when they're not admitted to the facility, they're being held in really extreme circumstances. So instead of being afforded, um, a cot or a bed in a housing unit, they're being held in the kitchen, in the library. We heard reports of many being held for 2 days on a bus. Um, Really, the government is saying it's a courtesy to hold them while they wait potentially a deportation flight, but they're being held for months and months on end in these conditions. And we, as attorneys, have no access to them unless we can get their A number somehow, but it's not in the detainee locator. So really, it is ripe with due process violations, both restrictions to access to counsel and really inhumane conditions that we're seeing on the ground.
And that's really troubling to hear. And I think something that you mentioned was access, and I think access to counsel is a challenge, across the board, and it's something that, in all the work that you all are doing, you see it every day. And if we have time, I want to come back and talk about that a little bit more as far as, with transfers and everything happening, what does that look like in representation? But I do want to turn it over to Amanda. Um, IJP does a tremendous amount of direct representation work for removals and removal proceedings, particularly those who are detained. We've heard, in the news and across the country, we've heard about these things called, motions to pre-termit and pre-termissions. Can you explain to to us what that is and what that means in practice. And again, this is one of those other things that since we started planning this, we did see a shift in how things are rolling out. So, Amanda, can you tell us more about that?
Well, thank you, Adonia. And Amy, I'm so sorry to hear about everything that's going on in the detention facilities in Texas that ProBAR serves. Yeah, so IJP represents a lot of people before the immigration courts here in San Diego, both the non-detained immigration court and at the detention center near the border in Otay Mesa. So a motion to pre-termit and pre-termission is a tool that has long been used in our immigration courts. And it prevents a respondent from being able to file a particular application that they want to file. For example, ICE might file a motion to pre-termit on an application for, say, cancellation or removal because perhaps they're arguing that the respondent doesn't have doesn't meet all of the eligibility requirements. Perhaps they have a criminal record that bars them. Perhaps they don't have enough of the physical presence, things like that. But last year, the Board of Immigration Appeals issued precedent case law urging immigration judges to bring pre-termission as an issue in their own authority by themselves without either party making a motion for it. And particularly when it comes to pre-termitting asylum applications. And judges can do that for any number of reasons, things like not being able to meet the requirements, not filing a full, complete application. But I think the most problematic reason for pre-termission of asylum applications for attorneys who are filing sufficient applications on behalf of their clients is for the alleged failure to demonstrate eligibility for asylum, particularly when their client's reason for fearing return to their home country doesn't fit squarely in established case law for asylum. What pre-termission allows an immigration judge to do is say, I don't even need to hear this case at all because to me, this doesn't look like a prima facie asylum claim. And what it does is it robs people their day in court. In the past few months, also, the government has been making motions to pre-termit clients' asylum applications a lot more frequently. We're seeing them drop in frequency for a certain basis called the Asylum Cooperative Agreements, but those types of motions by counsel for ICE skyrocketed in the past few months. What they're basically saying is that we shouldn't even hear this asylum application because the United States has an agreement with any number of about a dozen other countries to remove applicants for asylum to those third countries so that they can apply for asylum there. Basically, ICE is saying, since we have an agreement with those countries, your client's asylum application should not go forward here in the United States before this immigration court. We should put them on a plane to this third country. In our jurisdiction, the most common asylum cooperative agreement countries we've seen is Ecuador, Guatemala, and Honduras, if the applicant is Spanish speaking. And they should be removed there and apply for asylum there. In either case, whether it's the immigration judge moving to pre-termit or it's the government ICE counsel moving to pre-termit, we are needing to kind of have a whole mini hearing just to argue that we should be able to have our day in court for the asylum application we initially filed for our client based on their fear of return to their own country. So that's what's been going on lately with pre-termissions.
And a follow-up question that we got in the chat, I don't know if you're able to respond to this generally, but is there, any sort of thing that can be done with we've heard about cases about people being sent to a third country and perhaps being sent back to the country that they fear persecution. Are there, and I'm just directing you to the question here, is there an alternative order? Is the alternative order to send the respondent to country or country of refoulement. So maybe if you could talk a little bit about maybe arguments that are made with sending people to a third country, if you have any of that. And then I do want to flag that this policy we've learned has been rolled back recently through this the Asylum Cooperative Agreement pretermission motions. That doesn't necessarily, I believe from discussions that have been had, it's still applying to maybe motions that had already been filed or determined. There's no way to make necessarily perhaps go back and address that. But Amanda, can you talk a little bit about, you mentioned like the little mini hearing that's happening, but how are you approaching individuals that are potentially going to be sent to a third country?
Yeah, so the way immigration judges approach the country of origin has varied from judge to judge, even in our own San Diego Immigration Court. There are some judges who are saying that if you want to seek voluntary departure to the home country, instead of me considering a potential removal to these other third countries, then you have to tell me right away that you want voluntary departure before I entertain your opposition to this motion. There are some judges who are willing to entertain a removal order to that other country and avoid any removal order to a third country instead, but it really just depends judge to judge on how they want to conduct that pretermission hearing and what they want to set out as the options available and when. So it's a lot of like, there's a lot of strategy and guessing and going back and forth within our team, amongst ourselves, and also with our clients.
I was going to say, I imagine a lot of the internal discussions and creative lawyering that's happening is immense because this is very much sometimes new territory that we're coming into and having to like take novel arguments and like really break this down for clients. I did want to jump back. We did want to be very cognizant of time, but I did want to jump back, particularly to Amanda and Amy, with the work that you're doing. The detention facilities that you all work in traditionally had a lot of folks that maybe were recent arrivals, people that had recently crossed. I think your populations are changing. Can you talk a little bit how the populations have changed with the folks that you're serving? And then also briefly, any access issues that you may be having? And Amy, you touched on this a little bit with the courtesy holds, but just how with internal transfers and just transfers generally, how this is impacting your ability to represent individuals and work with people.
Absolutely. So this has really affected us in a variety of ways. First of all, and I wish I could show you all a graph, but we have seen the border be effectively closed to new arrivals. I mean, very few people are coming in through the southern border or any border, seeking asylum or really being able to get through at all. So a lot lower numbers, much lower than we've seen in years past. And that used to be the bulk of what we'd see at the detention centers at the border. Now we compare that to skyrocketing numbers of those detained in ICE facilities. So what does that tell us? That tells us, one, they're opening more facilities, and we know they're doing that, warehouses, tent facilities, other areas where they can hold people longer, but it is internal apprehensions. So they're changing their strategy of who they're detaining, and they're going after individuals that have historically been protected from detention. So we do have those that are in the country without status, no criminal history that may have been picked up. We are seeing that, but we are also seeing those that have been victims of crime, survivors of crime in the United States that have been eligible for non-immigrant visas, survivors of human trafficking that are eligible for T non-immigrant visas, survivors of domestic violence eligible for a visa called VAWA. And we are seeing that these individuals are getting appointments to check in with their deportation officer, and they're getting detained. And that's extremely challenging for those individuals. They may have bona fide determinations. That means we believe your case is approvable, but a visa is not available to you. So we are waiting until a visa is available to you. Even those individuals that have survived a crime, they worked with law enforcement, they too are being detained amongst many other individuals. So all of that to say is they are internal apprehensions, and then it is quite strategic where they're placing individuals. I'm working on a case right now for a single mother of two young U.S. citizen children that was detained in Tampa, Florida, and was transferred to ABA Detention Center in South Texas. She has a really viable case for cancellation of removal because she's been here for more than 10 years, and her departure from the U.S. would cause extreme hardship on her young children. But it has been extremely difficult to work this case, even though it's a good one, because all of her information is in Florida. And the judges are setting the pace of these cases so that it makes it extremely difficult to even submit the evidence in the timeline that we're provided. And that's when we can access them in the timeline, when an attorney can actually work on the case. So, factor that in on the many that go unrepresented as well.
Amanda, do you have anything to add? I do want to leave a couple of last word minutes. So if you have anything else to add to the comment, particularly maybe about any access issues that you're having. I know that IJP in the past saw a lot of transfers. You would start working with somebody, they'd be transferred to the other part of the country. I don't know if that's still the case, but can you talk really briefly about what it's looking like in San Diego?
Yes, so the transfers have not stopped, and that comes with its own issues with locating the client and figuring out how that new facility allows access to their attorneys. But I think on the issue with even local clients who are staying at the detention center here, it's just harder to get a hold of them and meet with them because of the crowding that's going on in the facility. The Otay Mesa Detention Center holds over 1,000 people, and they're consistently well above that number in terms of the population. So with that overcrowding, that means longer wait times when you go visit the client in person. It means it's harder to schedule a virtual meeting. It means that when you do arrive at the facility to meet your client, you might very well wait in the waiting room for a legal visit room to become available for well over 2 hours.
I think you've all highlighted just the many challenges that your staff face, dealing with how things are changing so incredibly quickly. If there's one thing people can take away today about how to best support your work, your teams, immigrant communities, what would that be? And I'm going to start with you, Kiana.
Thank you. There is a really dire need for volunteers to assist in the capacities they can, along with funding and donations. Thank you for dropping that in the chat. In terms of volunteer opportunities in the detention space specifically, as I mentioned earlier, our ABA Detention and Information Hotline, we operate 5 days a week. We're actively recruiting immigration attorneys. Our volunteer attorneys are guaranteed proper training prior to the shifts and a standby staff attorney mentor at all times to assist with calls. This is a unique opportunity to see what's happening in real time to our fellow immigrant communities and also see firsthand how these policies we're seeing in the news and the media impact on a personal level so many callers in ICE custody, not only in one state, but nationally. And if you're not an attorney, but still interested in volunteering with immigrant communities, we also have a project with the city of Baltimore, Maryland. We operate a hotline for non-detained immigrant communities in Baltimore. And there's 2 steps to the process that we're involved with. The first step of our services through the project is a legal intake. You'll have the opportunity to speak with the immigrant community in Baltimore, and for the intake, you do not need to be an attorney, and all intake results are reviewed by staff attorneys at the ABA. Once the intake is complete, Then we offer a legal screening. You can think of it like a legal consultation. So if you're an immigration attorney and are interested in providing that service to non-detained folks, you can also check the information in the chat about that. And we'd be happy to share more about how you can get involved. Again, the legal screenings are also fully reviewed by our staff attorneys before sending them off. And both of these options, both in the detained and the non-detained context, are completely remote. And you have a lot of support through trainings that we do prior to the volunteering opportunities and during the shifts themselves as well.
And Kiana is one of our fantastic mentors, and I can state that the team does a fantastic job in making sure people are supported. One more opportunity for folks that are maybe not attorneys and do not speak another language. The national team does have opportunities for court observation across the country. We want to get folks in the courts observing, collecting data. That's also information about that. Our court observation project is also on the volunteer link. I think Amy's typing right now the response to the Q&A. So Amanda, I'm going to go to you.
Yeah. IJP also takes volunteers. We take volunteers for piecemeal research and writing projects. But if you are local to San Diego and you feel like taking on a direct representation case, we are happy to mentor you if you want to jump in to help us out with that. But I think the biggest need for IJP is funding. The additional trips to the detention center, client meetings, added hearings, just to fight for your ultimate day in court. They're taking a pretty big toll on the organization. So your donation really helps make the work that we do more sustainable for our team.
And Amanda, I think that's important. With the work becoming more complex, it takes more time, it takes more visits, it takes more, gas and mileage to get out to the facility to see your clients, to really work on their cases. Thank you, Amy, for responding to that great question in the Q&A. How about you? What's the takeaway here today?
It's such an important question, and we get asked that a lot. Volunteering and supporting organizations like some of ours or even others that are supporting immigrants throughout the U.S. is critically important. But what I would also share is changing the narrative. We hear so much rhetoric in the news and so much misinformation that is passed around that really focuses on dehumanizing immigrants and treating them not as human beings. And really, I think making sure that you take the time to really understand, like you're doing today, what actually is happening and what is at risk. These are systematic due process violations to immigrant communities, and we know that they're going to affect and bleed into other areas beyond administrative courts. And we're already seeing that in other circumstances. So really taking time to make sure that in your daily conversations that you redirect something that may be someone repeating an area of misinformation, or you maybe refer someone to a credible source on a matter. It really is important that our language and our choices reflect our values because we're all in this together.
Beautifully said, Amy. And I do want to point that the ABA Commission on Immigration has a frequently asked questions portion of their website. We try to kind of keep up to date on what these things mean, how our programs are impacted. Please also follow us on social media. Not only the Commission on Immigration, but IJP and ProBAR are very active on the social media channels. You can learn more about what they're doing every day on the ground. I want to thank you all for taking time out of your day to talk just a few of the things that are happening that you all are dealing with, and the incredible response that you and your teams are doing every day for your communities. As we close, I want to leave all of you, our viewers, with this, that in moments like this, information, as Amy mentioned, information is critical, and connection are just as critical as resources. The changes that we've discussed today are moving quickly, Probably by the time that this is shared, this recording is shared, there'll be many other things that have been added or changed. So the impact, for the people that are most affected by this, they have little access to oftentimes to clear, timely information about their rights and options. So the work that our projects that IJP, ProBAR, and the Detention Hotline are doing is so incredibly important in trying to address some of the misinformation that is rampant in various detention facilities. But one of the most immediate ways to help is by sharing what you've learned today with your networks, whether it's your colleagues, your partners, communities, so that accurate information or where to get that accurate information is available to those who need it most. As at the same time, I think, Amanda said this best. At the same time, we need your support on the ground. It's never been greater, whether it's through volunteering your time, engaging your networks, or making financial contributions. All of these things supports the work that the programs are doing and helping individuals navigate the system, and so that they are not doing it alone. Again, these programs are meeting people at critical moments, and they rely on a strong community of supporters like you to not only sustain their work, but expand their work. The need is greater than ever. There is no single solution to the challenges we've discussed today and the challenges that will be coming tomorrow, but together, by staying informed, sharing knowledge in sessions like this, and contributing where you can, we hope that we can help preserve fairness, access to counsel, and meaningful due process in a rapidly changing system. So we encourage you to please stay tuned for future briefings. We want to do this more frequently, bringing in other programs, particularly our Children's Immigration Law Academy, CELA, to discuss how many of these things and many other actions are impacting immigrant children and youth. So please stay tuned for future briefings. I want to thank you for your time and your interest today and your partnership and commitment to this work. Thank you so much, and thank you to our panelists.